Can my will be challenged after I die? Hi, I'm Neil Tyra. I'm an estate planning attorney in Rockville, Maryland, and I do estate plans for regular folks like you and me. So, can someone challenge your will after you die? Well, the answer is yes, but it's harder than most people think. We're going to talk today about who can actually contest a will and what are the chances of it being successful. So, who can challenge a will? Not just anyone can contest a will. Typically, the person has to have what we call legal standing, which usually means has to be someone who would have inherited if the will didn't exist, or someone who received more under a prior will. In other words, they must have a financial interest in the outcome. So, for example, a child who is disinherited might have standing, but a neighbor or a distant acquaintance usually would not if they're just challenging the will to be difficult. So, what are some of the reasons why people might challenge a will? There's several legal grounds that people can rely on. Most typically, the number one is arguing that the person who created the will lacked the capacity to do so. This is a claim that the person who made the will did not understand either what they owned or who their heirs were or what the will was actually trying to do. So, in other words, they didn't really understand what they were doing. Another area where it can be challenged is under the premise of undue influence. This is when someone alleges that another person pressured or manipulated the person into changing their will for that person's benefit. And you sometimes see that when we have caregivers as a typical example. Fraud or forgery might be an area where people claim that the will is improper because the person who signed it was misled about what they were signing, tricked into signing it, or somebody forged their signature. And lastly, from a technical standpoint, people challenge wills if it was improperly executed. In other words, it didn't meet the legal requirements of the state, such as how it's properly signed and witnessed, and if it requires a notary or not. So, why are successful challenges rare? Well, they're first off, they're uncommon successful challenges because the court, generally speaking, respects the person's right to decide what happens to their property. And to overturn a will, a challenger must show clear evidence, not just hurt feelings. So, if you want to find out more about how to protect your will from challenges that can make things more difficult, give our office a call. Our information is at the end of this video, and we'd love to have an opportunity to chat with you about that. Again, my name is Neil Tyra. I'm an estate planning attorney in Rockville, Maryland, and I do estate plans for regular folks like you and me.